This is our chapter related with the equal employment opportunity. When we're talking about organizational values and when we're talking about organizational structures, so this chapter is one of the important related with the when we are giving the opportunities to the everyone. An employer cannot. This is the title V2. Uh, V means actually 7. Title 7 of the Civil Rights Act 1964. An employer cannot discriminate on the basis of race, color, religion, sex, or national origin with respect to the employment. Coverage all public or private employers of 15 or more persons, all private and public educational institutions, the federal government, and state and local governments, all public and private employment agencies, all labor unions with 15 or more members. Furthermore, is that Equal Employment Opportunity Commission consists of 5 members appointed by the President with the advice and consent of the Senate. Each member serves 5 years term. EEOC has a staff of thousands to assist it in administering the civil rights law in employment settings. Equal Employment Opportunity Commission may file discrimination charges and go to court on behalf of aggrieved individuals. Executive orders is basically require affirmative action steps that are taken for the purpose of eliminating the present effects of past discrimination. And then the other one is Office of Federal Contract Compliance Programs, OFCCP, responsible for implementing the executive orders related to affirmative action and ensuring the compliance of federal contractors. So these are some of the very important points related with the equal employment opportunity. The other aspects is the employment discrimination laws. Equal Pay Act of 1963, the act requiring equal pay for equal work regardless of the sex. Age Discrimination in Employment Act of 1967, ADEA, the act prohibiting arbitrary age discrimination and specifically protecting individuals over 40 years old. So these are some of the basic laws which is related with the discrimination. So students, you have to be know about that. What does the mean of the Equal Pay Act of 1963 in examination? I can be give you the statement of the Equal Pay Act of 1963. Or I can just ask you about what do you mean by the employment discrimination laws, and you have to explain it. So these are some of the laws that you need to be understand. Vocational Rehabilitation Act of 1973, the act requiring certain federal contractors to take affirmative action for disabled persons. Then moving further, we have to see it the Employment Discriminations Law, Vietnam Era, uh, Veterans Readjustment Act of 1974, an act requiring that employees uh, with government contracts take affirmative action to hire disabled veterans. So these are the some of the quality. These are some of the elements which we related. Then uh, Pregnancy Discrimination Act (PDA) of 1978, a Title B7 amendments that prohibits sex discrimination based on pregnancy, childbirth, or related medical conditions. If an employer offers its employees disability coverage, then it must treat pregnancy and childbirth like any other disability and include it in the plan as covered conditions. Uh, then we further move on. Uh, The other thing is the Pregnancy Discrimination Act. So the if an employer offers its implies disability coverage, then it must treat pregnancy and childhood. The other aspects is uniform guidelines, federal agency guidelines, uniform guidelines issued by federal agencies charged with ensuring compliance with equal employment federal legislation, explaining recommended employer procedures in detail. Equal Employment Opportunity Commission, Civil Service Commission, Department of Labor, and Department of Justice together have uniform guidelines for employers to use. Then we have to go on. The other thing is Title B2, sexual harassment on the basis of sex that has the purpose or effect of substantially interfering with a person's work performance or creating an intimidating, hostile, or offensive work environment. Employers have an affirmative duty to maintain workplaces free of sexual harassment and intimidation. Federal Violence Against Women Act of 1994, a person who commits a violent crime motivated by gender is liable to the party injured. Sexual harassment defined unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature that takes place under any of the following conditions. So these are some of the sexual harassment related elements. Uh, in Pakistan, there are some of the laws which are implemented in organization and offices where they do discourage such kind of the activities and such kind of the elements. So internationally and nationally, these are not acceptable. You can say that behavior. So the submissions to or rejection such in conduct by individual, there might be some cell available for the sexual harassment cell available, and they where people can complain, and then a committee can decide either that offense is justifiable or just a fake argument on particular issue. So these are the so next moving to the further is proving sexual harassment, quid pro quo. Rejecting a supervisor advances adversely affects the implies tangible benefits such as raises or promotions, hostile environment created by the supervisor's behaviors that substantially affect an employee's emotional and psychological ability to the point that they affect the employee's ability to continue with the employee's job. A style environment created by co-workers on or non-employees advances by the employees co-workers or even the employers customers can cause harassment. Then moving on further, sexual harassment court decisions. These are some of the court decisions. Just read it, and if you want to ask something, so we will discuss it. What employers should do to minimize liability in sexual harassment claims. Take all complaints about harassment seriously. Issue a strong policy statement condemning such behavior. Inform all employees about the policy and of their rights. Develop and implement a complaint procedure. Establish a management response system that includes immediate reaction and investigation by senior management. Begin management training sessions with supervisors and managers to increase their awareness of the issues. What employers should do to minimize liability in harassment claims. Discipline managers and employees involved in harassment keep records of complaints, investigations, and actions taken. Conduct exit interviews that uncover any complaints and that acknowledge by signature the reasons for leaving. Republish the